ask that everyone Okay, everyone, we are live now and unmuted.
I got one of my office today. Kazoos, yo-yos, slushies.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon, everyone. This is S-1-SC-39481, Grisham versus Van Soelen. Can I have entries of appearance, please?
Good afternoon. Sarah Sanchez and Richard Olson for the legislative petitioners.
And good afternoon, Holly Agajanian and Kyle Duffy for the executive branch.
Good afternoon, Daniel Gallegos and Carter Harrison for the plaintiffs' both parties and interests.
And good afternoon, my name is Dylan Lang, I represent the Secretary of State, defendant in real party of interest.
Thank you. All right, Ms. Sanchez, it appears that you have reserved 13 minutes for your presentation. Ms. Agajanian, 5 minutes. Mr. Gallegos, 20, and then Mr. Olson, 2. Is that correct? All right. Ms. Sanchez, you can take the podium.
Madam Chief Justice, and may it please the court. The plaintiffs in this case are demanding that the judiciary take on responsibility for deciding an inherently political question, involving nothing less than the reallocation of political power between the two major political parties, with no constitutional directive to do so and no legal standard to apply. This court should not agree to enter that political thicket, and instead should find that the plaintiff's complaint must be dismissed for 3 essential reasons. 1, plaintiffs have suffered no constitutional harm. 2, nothing in New Mexico's constitution, statutes, or case law provides any rule or standard for adjudicating plaintiff's claim. And 3, this court's decision in Maestas v. Hall not only fails to support plaintiff's claim, it supports petitioner's request for dismissal. Turning to petitioner's first argument. The United States Supreme Court has established long ago that the right to vote is individual and personal in nature, that the court's role is to protect individual rights of the people appearing before it and not to vindicate generalized partisan preferences. And certainly the role of the court is not to be involved in the allocation of political power between
Now,
the
if there's a
parties.
political question that impacts an individual right, doesn't U.S. Supreme Court case law indicate that this court can and should reach that issue? So voting is an individual issue, as you have just stated.
Yes.
Doesn't that move it out of, in extreme circumstances, out of the political question arena? And this goes all the way back to Marbury versus Madison, where we talk about generalized harm versus individualized harm.
And here, Chief Justice, the plaintiffs have not alleged an individualized harm to the right to vote. The harm—
Could they by filing an amended complaint?
No.
Why not?
Because on the face of the map that is being challenged here, we see that this is not a situation where plaintiffs' right to vote has been impaired in any way, and no clever pleading will change that. In fact, plaintiffs vote because each of the congressional districts in SB1 is drawn with exact equal population. Each of these plaintiffs' votes counts the
But doesn't
same.
that require us to go to the merits, which begs the question of jurisdiction in the first place? In order to reach those types of conclusions.
Your Honor, I think those types of conclusions are presented on their face, on the face of the complaint and the map being challenged, which does not require a factual inquiry.
But
And is
it
a legal
requires us
question.
to exercise jurisdiction to answer the legal question.
Yes.
Much
we're-
of what's presented here is that we have no jurisdiction, period, ever in this arena. And I'm frankly, I'm troubled by that broad approach.
And Madam Chief Justice, I would draw a distinction between whether the court has jurisdiction to determine whether there is a claim here and whether there is a justiciable claim for the court to resolve. The issue here is that there is not a justiciable claim, and the court certainly has jurisdiction to consider whether or not this claim is justiciable under New Mexico law. And it is not, because it presents a political question. The question it presents is how much politics in redistricting is too much. And in my Estes v. Hall, about 10 years ago, this court was essentially forced to get into the arena of redistricting and acknowledged in doing so, and this is from paragraph 28 of the Maestas decision, because the redistricting process is embroiled in partisan politics, when called upon to draw a redistricting map, a court must do so with both the appearance and fact of scrupulous neutrality. Here, the plaintiffs are attempting to use that same Maestas decision to drag this court into the political thicket, to make a political determination in that in a process that is inherently political and that this court has recognized is inherently political.
So what do I do with this kind of nagging concern? Can't help but note that if the shoe was on the other foot here, each side would be making exactly the opposite argument that they are today. And what are we to make of that?
I think without necessarily agreeing with the court's hypothetical, but I understand the question.
I've been around the block a few times. You all would be making exactly the opposite arguments.
Part of the issue, I think that highlights the issue here, which is that redistricting is part of the political process. Our Constitution assigns the task to the political branches. It is inherently a political act. And we live in a system where we have winner-take-all elections, we have partisan elections. Somebody's ox is always being gored. Somebody will always be unhappy with the map. Somebody will always be looking to challenge that. And the problem here is that the challenge before you is not one person, one vote. It is not racial discrimination. These are clearly justiciable issues that have been tested
Ms.
over
Sanchez,
time.
algorithms can be written which would redistrict, which would all but guarantee that a single party would win all three districts for the next 10 years. All but guarantee, with mathematical precision and certainty. If that were to happen, same argument, doesn't that feel antithetical to the very core of what democracy is?
So, Justice, well, first saying that is definitely not the case that happened
It's not
here.
the case, but if it's not justiciable, then it doesn't matter.
And the issue is that that's correct, Justice Vigil, because as the law exists in New Mexico hasn't joined the 20-odd states, right, that have constitutional amendments or have passed legislation that set a limit on partisan considerations in redistricting. New Mexico hasn't done that. And so there is no basis in our law for this court to jump in and make its own determination
Isn't
of how
that
much
the
is
very
too much.
antithesis of what a democracy is?
I think that type of scenario that you portrayed, Justice Vigil, is broken, right? But that's a problem with the political process, and there are many ways for the political process to address that problem. Here in New Mexico, for example, which is not true in every state, we have a gubernatorial veto over redistricting maps. We have the possibility of a constitutional amendment to put limits in power. We have the legislators who drew this map. We're talking about a congressional map. The legislators who drew this map and passed it don't benefit from that map.
Assuming assuming that we conclude we do have a valid claim and we remand this case back to the district court, what standard would you be requesting that we instruct the district court to use in holding an evidentiary hearing and obtaining the information needed?
Well, Your Honor, because there really is no standard in New Mexico law, it is our position that there is no standard that this court could provide to the district court.
We provide standards with some frequency as the Supreme Court.
That is
So
true.
we can announce a standard and remand.
That's true, but what would that standard be based on, Chief Justice? Because here, the guideposts, if you will, that the plaintiffs have relied on, the discussion of traditional redistricting principles in the Maestas case, or the principles that are enunciated in the Redistricting Act, neither of those are binding on the
Why
legislature.
can't we adopt Kagan's three-part test, which is nothing, I mean, I say Kagan, it's not Kagan's idea. It is simply an equal protection test. I mean, if you look at the underpinnings of the Kagan test, it echoes the equal protection analysis found in our case law in Griego and Breen. So why can't we do that? I think we are imbued with that power to create the test if we think one is available.
What I would say is this, and I would answer this in two parts, Chief Justice. One is that this, on its face, the claim presented here is so far removed from the type of a situation that Justice Kagan was talking about in her dissent in Rucho. So far removed from the type of scenario that Justice V. Hill offered.
The extreme
The
gerrymandering.
extreme vary.
But
Right.
don't we have
Now-
to agree that it's justiciable to answer that question? Even get, I mean, I can have my own veiled opinion about what happened here, but the parties have not even been given an opportunity to create that record.
Well, the parties have agreed that given what the court has now, the court has enough information in front of it based on the allegations of the complaint, the map being challenged, that it is appropriate for the court to consider this legal issue at this juncture. That is something that
But
the
it doesn't-
plaintiffs have agreed to.
Doesn't that distinguish, doesn't this posture, isn't it different than Rivera, Rucho, Harper, et cetera? Because there, each court had a fully developed record to consider before deciding whether something was justiciable or not.
It is true that in those cases, the process had gone further before it came to the Court of Appeals. But here, there's no need to do that. If this court remands for further fact-finding, further discovery, et cetera, we could engage in that all till the cows come home, and it's not going to change the fact of what this map does and the allegations the plaintiffs are making. Because what the plaintiffs are really complaining about here is that they were drawn into districts with a lower Republican performance measure than they were in before.
Mm-hmm.
There's no constitutional right to the same political performance that your district was before.
But that was the case in Rucho also, right? Both in North Carolina and in Maryland. The claim was that people were moved around into districts that were going to perform differently because they were moved.
It's similar in that regard, Justice Vargas, but it's very different in terms of the effect of the map.
But how do we know that if we don't have a developed record?
Well, what we have in the record thus far, even in plaintiff's complaint, is the very map that they're challenging. That is part, they've included pieces of the map, statistics from the map. The map is undisputed, and I would argue part of the complaint. And so we know that this is a competitive map. We know that CD2 was drawn within the competitive range that not only the case law, but also David Cottrell, who did the partisan fairness measurements on the CRC maps, determined between 45 and 55. It's a competitive district. We have all that information already, and so to send it back down would frankly be fruitless because it's not going to change the legal issues at play.
So I have at least 2 more questions. So imagine that we have what Kagan was concerned with, which is this extreme partisan gerrymandering, which is, I think, what Justice Vigil was getting to. Is that ever going to be justiciable? Ever? Because you're asking us to declare it will never be justiciable, and you better, everybody better agree that that's a good outcome, because that would then be the law of New Mexico. So that's one piece of my question. I'll do one at a time. That way it's fair to you, Ms. Sanchez.
Thank you, Chief Justice. So the first part of my answer to that question is we are only asking the court to decide the case before it. We are not asking the court to imagine whether there's any hypothetical situation which could exist.
So then how do we write that?
But under the state of the law in New Mexico, given our constitutional structure and the assignment of redistricting to the political branches with no limit on that, given this court's recognition that that process is inherently political, and given the fact that there are no binding standards, then yes, even in the extreme case, that is not justiciable by the court unless and until New Mexico adopts a constitutional amendment, legislation, something that it provides that almost half of the other states have seen fit to do, that provides a check on that process.
So, but we have this court could decide and follow the dissent in Rucho. That is a standard. And Rucho doesn't prohibit us under our state equal protection clause from entertaining such a claim necessarily. That really is what, I don't think that, I'm concerned with barring forever, assuming there's no statutory or constitutional amendments, claims of this nature, even in the most egregious cases. Because we obviously, recognizing it's political, I think the dissent in Rucho recognizes it's a political process. But for the really egregious extreme cases, to forever bar a claim is concerning to me.
And Justice Zamora, what I would suggest, my first answer to that is it's a political problem that needs a political solution. But if this court sees it differently and along the lines of what you just shared, Justice Zamora, that there has to be a line in the sand. That is not the position. We don't agree, but if the court were to do that, I would urge the court to consider that it would be the type of situation that would call for a heightened pleading standard, where what is being presented to the court shocks the conscience, is of such extreme nature. I mean, the language in Justice Kagan's dissent was really very powerful. She was concerned about those outlier cases where effectively it's election rigging, right? It's a stranglehold on democracy. I think we can all agree that's a troubling situation. So what I would suggest to the court is if that's the route the court chooses to go, to have the bar high enough that it, even from a pleading standpoint, that this has to be an extreme situation, because otherwise every school board race, every city council race, every legislative race, again, it's a political process. Somebody's ox is being gored. And if every time somebody feels they didn't get the political shakes they wanted in their district, they're going to come to this court. And I don't think that's what the intent is. So I would suggest a quite high bar if the court decides to go that direction.
2 more questions. Famous last words, 2 more questions. Kind of picking up on where Justice Zamora was like, I keep thinking about what do we write here so that we don't shut the door on that extreme rigging of an election type of concept. But also here, we haven't been asked yet to even do an interstitial analysis of our equal protection clause as it would relate to these claims. The only issue in front of me that I have been able to discern, and I'll ask Mr. Gallegos about this, is that this is looking at the federal equal protection rubric, period. There has been no other constitutional type of argument made under the New Mexico Constitution. So I think we also have to be careful not to write something that would foreclose those kinds of conversations in the future as well, because that's part of the development of the law. So what do we do with that we have this very narrow issue in front of us today? And what does that mean for 6 months from now through pleading amendment?
Well, I think that the court really addresses the question that's before the court, right? And the way that this has been pleaded. Now, I recognize that the plaintiffs in this case have invoked the New Mexico Constitution's Equal Protection Clause, but really have not gone further than sort of gesturing generally at equal protection principles to try to enunciate what they mean by that. I don't believe plaintiffs have even defined what they mean by political gerrymandering. And I can't define it for you, and I think that heightens the problem.
So let me tack on to that. So if we were to decide to say we announce by way of an opinion that based on the case before us, if it is that narrow that it's based on a federal interpretation of the Equal Protection Clause, that we agree with you, doesn't that just kick the can down the road so that you all are back here in 3 months or something like that? Because they're going to amend. We will not have announced any kind of standard by which we want a record to be developed. You come back, they would say, okay, well, here's how we think the record should be developed. Go back down and around the pole we go. So it begs this question of should we, if we think that there is a potential for justiciability out there, shouldn't we plant our flag in the sand and tell you all what we need to see to get to the final answer to the question?
Well, that may be true, Justice Bacon, but I don't see anything, there certainly isn't anything that plaintiffs have offered you in the way of standards to impart that would emanate from New Mexico's Equal Protection Clause. And we're here to basically agree that there aren't any, and that is why we're faced with a non-justiciable political question, because our Equal Protection Clause has certainly never been construed to mean equal representation in government or proportional representation in government, and it's a problem to start wading into those political waters and making those kinds of determinations that this court was so wise and so careful to avoid making in my Estes v. Hall, to be very clear, this court is independent and neutral and doesn't put its thumb on the scale politically.
Last question for the moment. Is it an important distinction that Rucho and Rivera had case and controversy language in their constitution that included political question, and we do not?
I don't believe so. And this court has recognized the political question doctrine. I believe it's the state ex rel call, the Johnson case, and talked about
it only goes about halfway
in passing, right? Yes.
It doesn't there's not a full-throated adoption.
No,
in Johnson.
But what we do have in New Mexico that is quite full-throated, Your Honor, is our separation of powers provision in our Constitution and all of the jurisprudence around that this court is so very much aware of its role, that this is not a political branch and that the activities of the political branch remain political and are outside of this court.
Yeah.
Go ahead, Tim. You kind of agreed that if we were to find that certain cases are justiciable, the bar would have to be very, very high. Tell me how we would define what that bar is. Because all of these, and I've gone through the Citizens Redistricting Committee report, it's pretty voluminous. It seems like it all comes down to the numbers. even their evaluation of partisan fairness and the model they adopt it looks like a mathematical model, at least to my misunderstanding probably. But so how do you define what that high bar is? Is it quality? What is it? What is it? Is it like, I hate to say this, but is it like pornography that you can't define it, but you know it when you see it?
Justice Vihil, that's such an excellent question. And the answer is that we can't define it. And that is the heart of the problem, because it is a political question, not a legal one. The question of how much is too much does not lend itself
But let me,
to a legal
the
standard.
committee was told not to ensure partisan fairness. And they did do that as directed by the statute and as part of their task. And they adopted a methodology, and they concluded that all three of their plans are, quote, fair. Even though they were, one plan is this, one plan is this, one plan is this. They were similar in certain ways, but different in other ways. And some members voted in favor of some and some against. So, I mean, there is a methodology, at least according to the Citizens Redistricting Committee, for doing that. But I guess the question is, when does it reach that threshold? And how do you determine what that threshold is? And I'm sorry for interrupting and speech making, I guess.
No, and I understand the sort of frustration with that, Justice Vihil, because it may feel like something that ought to have an answer that here's where the line is. I can't help with that, because there isn't a clear line. That is the nature of politics. That is the nature of the beast in terms of redistricting. But what many states have done was to say, no, we do want a measure of fairness. And so there is a constitutional amendment. There is a redistricting statute that forbids political considerations, for example, being taken into account. Here, the Citizens Redistricting Committee did a remarkable job and collected a huge amount of public input and data, along with the fairness evaluation that went along with it. And frankly, the map that came out of it, SB1, reflects a great deal of that. But the point is that is a separate process from the policy-making process that the legislature engages in. And if the court wants redistricting in New Mexico to be redistricting by expert or redistricting by algorithm, that would be contrary to the constitutional process that our Constitution sets up and delegates to the political branches.
Justice.
Counsel, this is the United States Supreme Court's most recent or renewed interest in the independent state legislative doctrine. Does that impact whether we should just wait to see what they decide in Moore? One of the things that could be, there could be a number of outcomes of that case. One could be to conclude that these independent citizen redistricting committees are themselves unconstitutional, or that the governor actually doesn't have any role in this process at all. Why wouldn't we just wait to see what the U.S. Supreme Court says on this?
Well, thank you, Justice Thompson. As an initial matter, I want to be clear that petitioners are not here promoting the independent state legislature doctrine. It is pending before the U.S. Supreme Court, and I've learned a long time ago not to try to predict how those kinds of decisions are going to come out. But
it is saying something similar, which is the judiciary has no role in this process, to different extremes.
Well, I think it's quite different, Justice Thompson, because the judiciary has quite a role with a number of things having to do with redistricting. One person, one vote, racial gerrymandering, there is a role. And I think simply because, that particular provision of the United States Constitution references state legislatures to designate the time, place, and manner of elections doesn't mean that no other part of government can play a role. So I don't agree with that argument that's being forwarded. Frankly, as best I can tell, I would certainly be quite surprised if the U.S. Supreme Court adopted such an extreme view, but I obviously can't rule it out. I can't predict. I don't have a crystal ball, but I don't see any reason for this court to hold off on coming to its own conclusion based on the law as it exists now.
Can I ask a follow-up? And this is a follow-up on Justice Hill's question about knowing it when you see it or whatever. I guess in my mind, a lot of what we do as the court, including in political cases like racial gerrymandering or any type of case, really is we have this spectrum and these standards. And in my mind, on one end, there's election rigging, which I would think that someone will be able to bring a claim for, but maybe not. We'll find out. And then there's something that's very clearly not a violation. And I'm wondering why we wouldn't be able to adopt standards or anything of that nature in this type of case. Why it's so different than really every other type of case we hear. I mean, is it really? I'm not sure that it is.
And Justice Moore, I think it is that different because we are talking about what goes to the heart of the political process, that the voters choose the representatives, not this court. This court doesn't determine where the lines should be drawn. This court doesn't determine how much political performance a given district ought to have. It is so inherently political and to the heart of our democratic process that it is vastly different from, say, the one person, one vote analysis, which is objective, mathematical, judicially manageable, has nothing to do with politics. Even in the racial situation, right? Race deserves special protection under our constitutional law, under United States constitutional law, and for all the reasons in this court's equal protection jurisprudence and so on. That is a measurable thing, right? Racial segregation in voting in elections is never lawful. And so the distinction between that and between how much is too much partisan consideration is they're miles apart from each other. And I don't think there's a legal standard. I think it's a political grievance with a political solution.
Chief, can I ask one more?
Of course.
Ms. Sanchez, I want to talk to you about what I understand the claims of the respondents to be. As I understand it, they're making a claim under the New Mexico Equal Protection Act that they are relying on as the standards they want us to apply, the Redistricting Act and Maestas, and maybe some traditional concepts related to redistricting. The Redistricting Act, of course, we know is not binding on the legislature. Why should we not still look to those standards when the legislature has said this is important enough that we want the committee to look at it and apply these standards, but we're not gonna bind ourselves to them? Why should we not take those standards and say we should at least look at those to determine whether there's an equal protection violation?
So part of the answer, I think, Justice Vargas, is that we must interpret and apply that law as written. And the Redistricting Act, for example, was expressly written not to bind the legislature and to so now use it, not only to bind the legislature or to hold it to account, if you will, but to hold a piece of enacted legislation unconstitutional. And I would just like to share with the court a passage from the Benavides case, the 2014 NMSC 037, paragraph 43, which stands out to me in this situation, and I think is pertinent to your question, Justice Vargas. The quote is, "We have repeatedly held that every presumption is to be indulged in favor of the validity and regularity of legislative enactments. A statute will not be declared unconstitutional unless the court is satisfied beyond all reasonable doubt that the legislature went outside the Constitution in enacting the challenged legislation." given that standard, Justice Vargas, I think that non-binding standards and considerations in either the Redistricting Act or that were discussed in my S-1-SC in the context of population deviations, which obviously is totally inapplicable here, falls so far short of that very high bar to look at invalidating duly enacted legislation. That we don't ignore them, and they certainly exist and they play a role, but as a way to determine whether conduct of the legislature is constitutional or unconstitutional.
Would that be the case if, for example, the legislature looked at these and said, we're not going to comply with any of them. We're not going to follow any of those suggested redistricting considerations. We're going to do something completely different. And it was maybe a little bit outrageous. Would we still not look at any of these?
Assuming there's no constitutional violation, in other words, no one person, one vote violation, the map comports with the Voting Rights Act and all the legal requirements, that they're single member districts, for example, is required by our Constitution, then no, those are not constitutional standards.
So they could disregard all of these and just say we're doing something completely different.
It is hard to imagine that hypothetical, Justice Vargas, because I think in any map, you're going to see, and again, it's not whether a map complies with all the traditional redistricting principles or doesn't, right? All those principles are in tension with each other. They are, to protect this community here means you've got to draw the line through this community there, right? There's all this give and take, myriad decisions in the map. So I think it's hard to conceive of a situation where it could be that black or white.
Thank you.
Thank you.
Thank you.
Ms. Abajanian.
Thank you. Good afternoon, Your Honors. I'm Chief Justice, Counsel, may it please the court. After that vigorous questioning by Ms. Sanchez, I expect you guys don't have any other questions for me, and then you just want me to go sit down. Is that right? Is that good? Okay. I am not going to start at the beginning of my speech that I have written out here again, just because Ms. Sanchez has already been over huge parts of it. But there were a couple questions that were brought up of Ms. Sanchez, and I think that they're perhaps worth expanding on a little bit, elucidating on. And here's one that I think is super important, and that is this: that if the court ruled that this is not a justiciable claim, I think whoever it was that asked the question, and Justice Bacon, it might have been you, and the way you phrased it was, does that forever bar us from looking at these, right? I think that the answer to that is a ruling from this court. What that does is that tells the people, the voters, and it tells the legislature that there is potentially a problem and a potential solution. It's just that this court doesn't have it. I am cringing at the idea of being the one to tell you guys that you can't do it, right? But you can't, and I'm sorry, but that is sort of our position in this, right? Like, even if there is an individualized alleged harm, the court still doesn't have any manageable standard to adjudicate it. And so, therefore, it kind of has to be a non-justiciable question. And I note that the plaintiffs themselves aren't able to articulate a standard that the court could apply either. And that, again, that's because there is not one. And what we have in our case and in our constitutional history is the idea that during the Constitutional Convention, this exact issue was actually contemplated. This is in our reply brief in a footnote, I think footnote 6, where it's actually contemplated during the Constitutional Convention that they talked about the idea of districting and whether or not it should be fair. And the people in charge at the time, to your point, said, no. We're not saying that it has to be fair. It's written in. And it sort of does get to our definition of fairness, but I would note that there are a lot of things in our system that a lot of people don't think are fair. I keep coming back to the Electoral College, right? That's the way, that's the forum that we are stuck with in elections. So it might not be fair to some people in their mind that 2 elections ago, somebody won the Electoral College, but not the popular vote. In some ways that is fundamentally unfair, but that is the system we have. And I understand that it probably kind of gets your all hackles up a bit for us to tell you that there's no standard you can
Well,
invent.
the other thing that gets the hackles up is we're not used to making decisions where we don't have a lot of facts. And
Certainly.
the other problem here is you're saying no standard, okay, you don't, but the other thing is there's just no record. And even as was pointed out earlier, at least some other courts had the benefit of a record, and we don't have that. And I don't see why that process shouldn't be allowed to play out.
And to that point, Justice Thompson, what I would say is that's where I think that's where we get to the Rucho problem, right? Which is they had all of it. They had reams of their facts, and the U.S. Supreme Court still couldn't come up with a standard and still couldn't decide. They could have opinions on what it was that had happened in North Carolina.
Why couldn't we use the standard in the dissent in Rucho?
I think that you can't use that standard because, again, in this case, what it would do is this court would be creating policy and substituting its own preference for what standards should be instead of the legislature, and that's where the separation of powers issue comes in, Justice Amar.
More fundamental, we would have to conclude that this is an egregious case, whatever that means.
Right. Well, and again, I think unless and until you get to a violation of something, an already recognized constitutional injury, like a violation of the one person, one vote standard, I don't think that there is a constitutional injury for political gerrymandering. As Ms. Sanchez said, it's something that we kind of struggle to even define at this point.
So you believe our Constitution allows for election rigging if it's based on if it's based on partisanship?
I think I have the answer to that question written down. Right
Okay.
I expected somebody would say it.
I'm so glad I asked the correct
Yes,
question.
let me say, I am not that cynical. No, that's actually the answer, one of my different ones. But so I think what it is that just because something might be considered, again, anti-democratic, doesn't mean that the court has to step in. And I know that doesn't feel right based on what everything we think justice is. It feels funny for me to say that. But at the end of the day, the fact of the matter is that's the case. Because our system of government can only be these anti-democratic effects that we see can only be remedied through the legislature.
All right, thank you.
Thank you.
Mr. Gallegos.
Put on the microphone. Good afternoon, Chief Justice Bacon, members of the Supreme Court, and may it please the court. My name is Daniel Gallegos, and I, along with Carter Harrison, represent the plaintiffs in this case. And the plaintiffs brought suit against the legislative defendants, the executive defendants, and the Secretary of State, alleging an unconstitutional partisan gerrymander in violation of the state's Equal Protection Clause. And as to the issue of whether or not we're dealing with a individualized constitutional injury, I think it's important that if you look at Justice Kagan's dissent in Rucho, she states politically discriminatory gerrymanders not only violate democratic principles, so this idea that it's antithetical to representative government, but they also impose recognized injuries on individuals under the federal Constitution, particularly as violations of the 14th Amendment Equal Protection Clause. And she discusses specifically the constitutional harm that we are alleging in this case, and that is cracking of voters. And she talks about cracking and packing voters and describes that as basically vote dilution. Cracking a district results in one party supporters being divided among the districts so that they can't get a majority in any one district. In Maestas versus Hall, this court said that the right to vote is the essence of our country's democracy, and therefore the dilution of that right strikes at the heart of representative government. So the allegation is that this cracking that occurred down in the southeast portion of the state imposed a constitutional harm on individuals, including the plaintiffs in this case, in violation of the Equal Protection Clause. And so
Are you saying the last election was not competitive?
It was competitive.
So
Your Honor.
how much competitive, or how much lack of competitiveness, I don't know what the word would be, rises to the threshold of a constitutional violation?
Well, that's the big question. And the discriminatory effect, looking at the impact of this is really a methodological question, as you brought up, there's different formulations of ways to look at partisan fairness. In this case, the election would be one data point. We would argue that the fact that the incumbent Republican lost following this redistricting, although it was a competitive race, is a data point that shows that the purpose behind this map making.
How do we know that she lost because of the unregistered voters voting for her competitor?
And that's
So
why,
not Democrats or Republicans.
and that's why I say it's one data point. I don't know that it
But
tells
is it
the
a
entire
data
story.
Is it a data? Or is it a qualitative thing as well?
Well,
I don't know. I mean,
no,
tell me.
and that's a good question, Your Honor. And I think it would have to be looked at in the light of a totality of measurements in order to determine.
Because I
what
can
the
see
partisan fairness is.
redistricting happening, and then the party that loses is charged with, maybe killing baby seals. Just to use something really, extreme that most of us would say would be, like the death knell of somebody's campaign, then I don't think you can use that data point with any intellectual honesty to raise an extreme gerrymandering case.
And I agree that what data points are being used is a question, and I think it's a question for the trial court. And I think that given where we are in terms of trying to build the record towards, our claim is excessive gerrymandering, that this constitutes that egregious nature of gerrymandering.
So
Now,
you want the opportunity to, assuming we say there's this type of claim under the New Mexico Equal Protection Clause, you want an opportunity to have it remanded, or are you fine with what's in the record?
No, we want it remanded. We want the opportunity to prove our claim. We are at this point, and we agreed with the petition that asked this court to take this case up at this point with respect to that question. Is this kind of claim justiciable in New Mexico courts? Because if the
Under
answer,
what constitution, going back to the Chief Justice's question, under which constitution, number one? Number two, what is your authority if you're going to answer U.S. Constitution? What is your authority other than the dissent that it is judicial?
well, we made the claim under the state constitution. We made, I believe, in a footnote, I think, in our response to the petition.
But you don't engage in the interstitial
And
analysis.
it was not a robust interstitial analysis. The authority would be the state constitution, and it's basically coextensive. But we would argue that in this case there are different state interests
So what are the
involved here.
standards you would like us to apply if we're applying the state constitution?
The standards would be basically the Rucho dissent, the discriminatory intent, discriminatory effect. If we can prove those two, and just to be clear, Justice Kagan, in describing that test and going through, basically said that if the test is applied properly, you're really only going to be striking down the most egregious cases. What we're asking for is the opportunity to present our case and to argue in front of the trial court that this is one of those cases, and not to have the courthouse doors closed on us, and for us, as they say in Rucho, to have our complaints echo into a void. This will allow us to bring this claim. It's an equal protection case. This court, we have separation of powers.
Let me ask you this question. In a situation redistricting where, let's go back to my Estes, where the court is asked to draw the map, right? It seemed, yes or no, that one of the court's considerations should be partisanship. No, right? If the court's drawing the map.
In terms of the court drawing the map.
Okay, so isn't that where we're at? So no in that case, why yes now?
Well, We're not asking the court to draw the map. We're asking the
No,
court to
you're not
engage.
asking us to draw, but you're asking us to take into consideration partisanship, which a court wouldn't do, I don't think, in drawing a map.
And that went back to the idea of judicial independence and staying neutral. I do not believe that in protecting constitutional rights, that this court must be completely removed from every factor that you're interpreting and you're viewing the evidence with an equal, we do those kinds of tests all the time as far as equal protection. Courts can do that. Courts are called upon to do that. It's the court's duty to protect the rights of all citizens in New Mexico. And so we have separation of powers. There are a lot of powers, lawmaking in general, that is given to the legislature. And they say, this is your prerogative. We don't make law. Courts don't make law. The executive doesn't make law. Legislature makes law. And yet, the legislation is still subject to judicial review. And that's where we are here. And I don't understand what makes the map making so special that it should be removed and judicially immune or immune from judicial review the way other pieces of legislation are.
I think they're saying it's a claim that's immune, and it's a claim, if your claim is narrowed to partisanship, that is immune. I don't think they're saying the map, if there are other infirmities. I think she acknowledged that on my question. She's saying if you're going to narrow the claim to partisanship, yeah.
And I would argue that let me move on to the justiciability question. That really is the question that's facing this court. And on that question, I can't remember who my glasses keep fogging up. Someone brought up Article 3 of the federal constitution and the case in controversy requirement. And really, in Rucho, that's where they based the non-justiciability of this question. This is a political question under Article 3. It's not a case of controversy. And they actually said, it's outside our jurisdiction. We can't even hear this. Our justiciability doctrines here in New Mexico are not based on a case of controversy requirement in the state constitution. And in fact, the vast majority of our case law is that our justiciability doctrine is based on prudential considerations. And we have very little in the way of political question doctrine. I think I looked up political question doctrine on Westlaw and I got one hit back, and it was the title of a law review article in one of the cases. If you look up political question, you get about 20-ish, but Call versus Johnson is really the only case that even has anything to do with political question. And it's a simple citation of Baker versus Carr saying factors to consider in determining a political question. And so we have a very, very underdeveloped political question doctrine here. We have prudential considerations when it comes to the political question doctrine. And when we look at some of the other prudential items like standing, like mootness, this court has been, I think, fairly, I don't want to say lenient because that's probably the wrong word, but has been apt to take cases even where you don't have what would equate to Article 3 standing. They'll confer standing when it's a great public importance matter. And so I would argue, first, I do believe that there are clear standards that can be applied. And that's what we argue for. We argue for equal protection standards, discriminatory intent, discriminatory.
You're not asking for standards. Let me get back to a certain point you made earlier where you said what you want is a remand.
Well,
what you want is a remand. You said that loud and clear, right? Paragraph 17 of your complaint, plaintiffs asked the court to set aside Senate Bill 1 and to adopt a map proposed by the New Mexico Citizen Redistricting Committee in order to vindicate the rights of New Mexico to congressional districts that do not illegitimately favor the political interests of one group over another. Your prayer for relief. B, declare that Senate Bill 1 violates the New Mexico Constitution. C, adoption of a partisan neutral congressional map consistent with congressional concept. E, Justice Chavez's map, which as I understand it, it's map E in the report here.
Yes,
So you're not asking in your complaint to develop facts, you're saying declare this unconstitutional on the basis of this complaint and asking us in turn to adopt E as opposed to one of the other two plans that the committee developed consistent with its mandate.
Well, Your Honor, what I
So
would say.
are you asking us to remand or not?
We are asking for a remand, and we are asking that if this court sees fit to instruct the district court as to the standards of which to apply,
What standards?
and that's the equal protection standards of discriminatory intent, discriminatory effect. That would be coupled with, as Justice Kagan in her dissent says, on the flip side, there would be an obligation of the government to come forward with
It's rebuttable.
basically to rebut those.
And
And
how do you prove discriminatory intent?
well, in this case, we don't have a factual record, but given our complaint, we have direct evidence of intent, which is something you usually don't see. It's very rare to see direct evidence of intent, but we have that here. We have statements from the Speaker of the House. We have statements from a senator that indicate the intention of the legislature. We also have circumstantial evidence, not only the fact that the legislature did not follow maps that were drafted using traditional redistricting principles and partisan neutral, basically built to be fair. The legislature.
So I think when you said standards, you mean us instructing, for lack of, I can't think of a better word, but a test for the district court to apply. Or
That's
certain factors or whatever. Is that what you were asking?
That's what we would
Yeah.
say, is the test to apply. So we're basically arguing equal protection, but there are also ways circumstantially to get at the intent of the legislature by looking at the fact that they basically ignored traditional redistricting.
And if we believed that you did have a claim, but we also agree with the dissent in Rucho that the claim would have to be egregious, just, you're jaw dropping. How would you suggest we make that clear in our opinion?
I think the standard itself in Rucho, that Justice Kagan makes it clear that in order to satisfy that standard or that test, it would have to be an egregious gerrymander. And again, that's what we're arguing happened here. What we want is the opportunity to do so without having the doors to the courthouse shut on this kind of claim, a claim that someone's vote has been diluted by the actions of the legislature and that those actions were discriminatory. They were intended to be discriminatory and they had discriminatory effect. Now, whether we're successful at the trial court level, that's a different question. And that's not what we're here today for. We strongly believe we will be. That's why we brought the claim. But the question here today is, can we go back to the trial court and have our claim heard by a court here in New Mexico? And to your question or your comment, I think earlier, Justice Vigil, Justice Kennedy in Veith versus Jubileer, in his concurrence, it was basically the controlling opinion, but he asked kind of this hypothetical question. If districtors declared that they were drawing a map so as to most burden the votes of Party X's supporters, Justice Kennedy said that would violate the Constitution.
What if the election proved them wrong?
Again, I believe.
That goes to the effect.
I agree.
So can you ever litigate one of these claims until after the election?
Well, and that's kind of a, again, what I would say is that's a data point that would have to be considered by the trial court in determining the effect. I don't know that that's the entire effect.
Could you ever determine the effect without an election?
You can. You can, and it's through those statistics, the various tests that are out there. And all the names are escaping me right now, but the means, median tests, and all of those tests that are designed. And actually, in North Carolina, when they found a partisan gerrymander and they sent the case back down, they basically sent it down saying, look at discriminatory purpose, look at discriminatory effect. And then they named a few of these methodological tests that could be applied. They said, we're not going to give you an exhaustive amount of tests to use, because that should be for the trial court to have some flexibility in determining what tests should be used to determine the effect. And just within the last 2 weeks, the case, I think it's 2022 and CST 121, that's close. It just came back, and again, the court looked at all of those, and they're experts at the trial level in doing it. They used all of those methodologies and basically put them all together in order to come up with a conclusion as to the effect. And I think that can be done here. These are things that, every time you look, I know there was a statement that we don't do redistricting by experts, but like everything I turn to always has experts. And whether it's Brian Sanderoff or the expert in this case, there's always a lot of numbers going on. These things, we are capable of using these tests and these mathematical applications in order to determine effect.
So hypothetically, on the remand, you have a remand. One side brings in one expert, one side brings in the other expert, give diametrically opposed opinions. The trial judge rejects one and adopts the other. What happens on appeal?
Now that'd be pretty
Do we have to do a retrial or true de novo review, or what happens?
I think it would be the normal standard review of facts and factual findings by the district court. And if the district court determined that one was,
So just an abuse of
I
discretion.
think it would be abuse of discretion or sufficiency of the evidence.
Or, yeah,
I don't-
substantial evidence.
I do not believe that this court would be in the position of having to try this case.
What distinguishes this case from Rivera?
Rivera was very clear that they had no standards at all that they could point to, whether within their own statutes or within their own case law, that they could use. And that's where we argue that the traditional redistricting principles have been used in the state for basically at least 30 years, according to Masters versus Hall. First, as put forth by the Legislative Council, by the legislature as guidance for how to engage in redistricting. It was used by the courts, both in right around 2000 in that cycle, in reviewing the maps. It was used by Maestas again, and it was very clear that those traditional standards are widely recognized by courts. They are neutral, they are objective, they are ways to test the motives of the legislature.
How do we address the fact that the legislature has basically found them non-binding in the Redistricting Act?
They're not necessarily binding. They did themselves use those and seem to have found them persuasive enough to go from the Legislative Council and then within our case law to then being enshrined within statute.
How do you raise those from the level of being non-binding to the basis for a violation of a constitutional right?
The question that we have on the justiciability issue is the question of clear, manageable standards, right? Objective standards that the court can apply. There's nothing within that framing of what constitutes a standard that says that standard has to be binding. We have a 30-year history of using these traditional redistricting principles. It should not be a surprise to the legislature that their work in making maps would be tested against neutral, objective, historical provisions that even within Estes versus Hall, were looked at as basically state practice. They were used
I
on the-
mean, now it seems like you're arguing for a different standard because I think we can all agree that redistricting can take partisan considerations into account. I mean, it is a political process. I think the concern is when it's outrageous or egregious or jaw-dropping. So I don't know that, I'm not sure, I just want to be clear, you're not asking us to adopt those particular standards that have 30 years of history.
What I'm asking is that when the trial court,
The trial.
looks at discriminatory intent and discriminatory effect, that those provide baseline standards that the court can use in making that determination. So it's unlike Rivera, which said we don't have anything. They even mentioned traditional redistricting and said we had proposed guidelines. They were never put into law. We don't have anything in our case law. We don't have anything. And so we're not going to use that. So here, I do believe that we're closer in line to some of the states that have, there are states, obviously, that have more robust provisions, either within their constitution or within their statute. We're not there, but we're part of the way there with these traditional redistricting. And the question is, the major question is, if the courts sit it out and say, we're going to shut the doors, the response from the legislative defendants and the executive defendants is, it's a political process, work it out. Justice Kagan in her dissent says, these are the kinds of cases that are the most important that we get judicial review, because the interests of the politicians who are seeking to entrench themselves in power are diametrically opposed to the people who are asking for relief. And so a political problem is we have an intentional gerrymander to basically dilute the votes of one party. And the solution, if this court says this kind of claim cannot be heard in a New Mexico court, the solution would be take that to the legislature who just said what they were going to do. We're going to gerrymander that district. They gerrymandered the district, and then they told you, we gerrymandered the district. And our only option at that point would be to go back to them and expect that the political process is going to work out for us. The only place where the plaintiffs can vindicate their individual constitutional rights is in a New Mexico court.
Thank you, Mr. Gallegos. Any other questions?
Do you or your client wish to announce a view on the independent state legislature?
Should we wait?
Should we wait?
Should you wait? I think when it was early on in this case, and it may have even been during the petition, there was a suggestion, I think, by the petitioners that we wait, and we took the opposite tack. We said, let's get this decided.
Thank you.
All right, Mr. Olson. And I have a question for you the minute you get to the podium.
Thank you, Justice Thompson. Justice Bacon, you said you had a question?
I do. So looking at constitutional history and political questions, the kind of the big dog in this, other than Marbury versus Madison, is the Baker opinion, U.S. Supreme Court Baker opinion. And Baker does something interesting that I don't think any of the parties have talked about today, but Baker actually stands for the proposition and says that the courts cannot reject as no lawsuit a bona fide controversy as to whether some action denominated political exceeds constitutional authority. And Baker goes further to say, because Baker is focusing on the guarantee clause, says, but differentiated due process and equal protection cases are potentially justiciable, notwithstanding its point of view on the guarantee clause. So Baker actually stands for the proposition that challenges like this are potentially justiciable. What do we do with Baker?
Well, but I think the difference with Baker, Your Honor, Justice Bacon, is that in Baker, there were some clear standards. The standard was one man or one person, one vote. That was the issue being dealt with in Baker. That was an easily defined standard, a standard that was incorporated clearly in the Equal Protection Clause. And because of that, that particular issue was justiciable.
But their statements are much broader than the individual one person, one vote concept. They lay out a broad rubric for, we can't declare something untouchable by the courts just because it's labeled political. And in fact, it's the court's responsibility to examine that against the Constitution in some fashion.
I understand their statement was much broader, but it still requires examination against the Constitution. When you take the New Mexico Constitution and look at it, there's really no standards by which you can determine what is at its root a political question. I mean, I think the discussion we've had here this afternoon highlights the difficulty with finding any standards. I mean, for instance, how do you determine what the intent of the legislature was? You maybe had a couple legislators mouth off. Does that mean you go through and you have to basically depose every legislator, or at least every legislator that voted for the bill, as to what their intent was? How do you determine, if you use Justice Kagan's test, what is a substantial dilution of votes? Who is it that's being protected? How much do you determine what is too much? Where do you draw the lines? Are you trying to protect incumbents? Are you trying to protect parties? Or are you trying to protect individuals? I mean, the discussion we've had today clearly highlights the difficulty in finding any sort of applicable standard. You can run algorithms, just as Vigil said. You'd have one group of experts say one thing, another group of experts say the other thing. And then at the end of the day, you'd have a court jumping into the political thicket that 10 years ago, Justice Chavez indicated this court probably really didn't want to deal with it, but it had to, because the political branches didn't do their job.
All right. Mr. Olson, thank you for your more than 2 minutes.
Thank you,
Seeing
Your
no
Honor.
questions from my colleagues, we will end there. Thank you to counsel for really excellent presentations, for a lot of robust questioning. The court typically in an extraordinary writ would attempt to convene and reach a decision today. We are not going to do that in this case. This is an issue of significant importance, and we want to be deliberative. And because there's a stay in place and we're a little ways out from the next electoral process, we don't feel the need to act as quickly as we might otherwise. So you can deem, as of today, this case is submitted for decision, and we will get you the outcome as soon as practicable. Thank you very much.
And the court, please.